But I love it. I enjoy.
today, but I'll start with the perfunctory statement of public notice. Public notice of this meeting was properly posted at the Soil Classifiers Advisory Council Office, Synergy Business Park, King Street Building, and provide all requesting persons, organizations, and news media in compliance. Section 30480 of the South Carolina Freedom of Information Act. I'd like to entertain a motion to modify our agenda this morning, just to switch to agenda items, which are applicant hearings ahead of the staff reports, out of deference to their time here. I'm the chairman of the board here. I've been licensed since 1998 and in practice for on-site waste since 2005. And I operate out of Charleston as a private soils consultant, classifier.
My name is Chris Fincham, out of the Newberry area, vice chair.
Lance Brewington, Soil Classifier Board member, retired NRCS, 31 years service to government, and then currently Piedmont Soils and Wetlands.
Jason Goff, South Carolina Department of Environmental Services, and also Soil Classifier, technical advisor for the department.
NRCS, owner and president of Coastal Soil and Wetlands.
Like we have full attendance here, so there's no absences to. Oh, I'm sorry. Forgive me.
Oh, you're fine.
Yeah.
Johnny Rose, Board Executive.
Mary League, Advice Counsel to the Board.
Gang's all here now. Thank you. Okay, so like we don't have any excused absences to approve. Thank you for attending, Mr. Fowler. Good to have you back. So have we all had a chance to review the minutes of the last meeting? Marks or changes needed?
Aye.
Opposed? The motion passes. Thank you. An interesting year for soil classifiers. I'm remaining super busy. I guess it's a blessing and a curse that our state has been deemed the fastest growing state in the United States of America. I don't know where all these people are coming from or what they're doing for a living, but they have to live somewhere. And so guess what? They have to have either sewer or septic, and that falls right into our lap between DES and private classifiers. There's a lot of work to do. Traffic like never before. I'm a little troubled that among our ranks, we're going to have a disciplinary hearing, not today, but in the future. I want to say in general, our profession has been very well behaved, with very few incidents or trouble, and I'm also glad that we have new applicants today, because the state, our profession, does need more good, qualified, and ethical soil classifiers. Updates from our board members they'd like to share? Okay, let's proceed. Now I'd like to move into the application hearings. First on deck is Mr. Jan Gay. Would you like to come forward, sir?
Mr. Gay, if you don't mind, just have a seat there for us. And you'll speak directly into that microphone once we get to those question and answering period, okay? Thank you.
And Mr. Gay, you'll know that your voice is being picked up. If you see the little red ring around it, that means your mic is hot. And these proceedings are being live streamed on YouTube for anyone who's interested. So it's very important, the camera's in the back. So it's very important that someone who's here, who's out there and listening can actually hear. So you may need to move it really close to you. If it seems like it's intrusive and uncomfortably close, you got it.
Welcome, Mr. Gay. I'm going to order now. This is the matter and Gay. The purpose of this hearing is for the council to make a recommendation to the department with regard to the applicant's qualifications to be licensed as a professional soil classifier by comity pursuant to South Carolina Code of Laws, Section 406536D and 406530, as well as the South Carolina Code of Regulations, Section 1082B. Everyone is reminded these proceedings are being recorded and that all witnesses must be sworn in before they testify. And kindly direct your remarks to me, the chairman. Thank you. My name is John Thorpe. I'm the chairman of the advisory council. The attorney assigned to advise us during the hearing is Mary League. Thank you, Mary. Office of Advice Counsel with LLR. Other council members are here and they've been introduced. So, Mr. Rose, did council members receive the complete application package?
Yes, they have.
Excellent. What questions did staff have concerning Mr. Gay's application?
Thank you, Mr. Chairman and other council members. Mr. Gay submitted an application for licensure by comity as a professional soil classifier on January 14th, 2026. Mr. Gay was licensed in North Carolina as a soil scientist through grandfathering on February 3rd, 1997. He obtained a Bachelor of Science in General Forestry from Louisiana Tech University in 1989 and a Master of Science in Forestry Ecosystem Modeling from Clemson University in 1992. Mr. Gay has 31 years of experience, and he's passed the Soil Science Society of America Fundamentals examination and also the Professional Practice of Soil Scientist examination on January 1st, 2025. For licensure by commodity, an applicant must hold a registration or license in the practice of soil classifying, awarded on the basis of comparable qualifications, and must be in the opinion of the department, meet the requirements of the council's licensing statutes and regulations, and specifically herein, whether the applicant meets the education requirements of 15 or more semester hours of approved soil science courses. Department staff is requesting recommendation from this council regarding Mr. Gay's qualifications to be licensed here in this state.
Did staff subpoena any other persons to be here today to answer questions we may have?
No, sir, we have not.
Jay, are you represented by counsel by chance?
I am not, sir.
Very well. You understand you have the right to be represented by counsel of your own choosing.
Letter that was sent to me, sir.
So you're electing to waive that right and represent yourself? Fair enough. Do you have any witnesses you intend to call before us this morning?
No, sir.
Okay. Ready to demonstrate or show us how your education meets our requirements for licensure?
Yes, sir.
Please proceed.
The courses that I took, for the most part, were self-explanatory in the names such as pedology and some of the basic soil sciences. The one course that I had that does not fit into the basic premise of is this a soil course or not was during my master's work. It was Forestry 8050 and Forestry 8100 dealing with forest landscape ecosystems. My master's work centered around an ecological model to determine long-term vegetation that was specific to any given area. Basically, we were looking at the interaction between soils and landscape position to determine what should grow in these areas. My degrees are in forestry with a concentration in soils, and this seemed a natural fit for me. Landscape position is very easy to figure out if you've got a compass that can tell up from down. The issues that we were dealing with, and my focus was collecting vegetation data in older growth systems and tying those back to the specific soils that were on site. So this class and the lab that went with it were a heavily soil-focused course in collecting data, being able to quantify the different layerings through there, as well as classifying to series when possible. And then followed by endless hours in the lab, titrating and running different textures. This is the class that when I was first licensed in North Carolina that came into question. 27 years ago, when I went through this, my major advisor wrote the letter explaining what this course went through. I've spoken with him several times in the last 6 to 8 months. He says he's going to look into it, he's going to write the letter, and I don't know if he saw something shiny or got distracted or something, but he has not done it yet. This is the main course. This was my focus in school, was soils, throughout my career once I got to Louisiana Tech, and then until I got in and out of grad school, because it's fun. But that's the main course that comes up. The rest of the courses are self-explanatory, pedology and the rest, but this is the specific course. Then some of my master's research courses, I had to teach undergrads how to, some of the basics of classifying soils, what each different horizon meant, and the rest, because I was a grad student and that's what you have to do. But this is a specific course that will fill the last hour requirements up to 15 hours to meet the board's needs.
Can you please repeat the course number?
It was FOR 8050, FOR 8100, Forest Landscape Ecosystems.
That was the title for both of them.
One was Forest Landscape Ecosystem, one was Forest Landscape Ecosystem. It says GSM, and this was 40 years ago, so I don't remember what all the letters mean.
Thank you. My review of your coursework shows, just to be clear, that at Louisiana Tech, you took a basic soils course with a lab, and you were awarded 4 credit hours for that. Then you took a forest soils course that was 3 credit hours. And then the Clemson pedology, straight pedology class was 3 credits. That brings you up to a total of 10 hours.
Yes, sir.
And our requirement is 15.
Yes, sir.
So your landscape study was admirable, and if you did practice classifying either instructionally or in the course of your, work for the paper, what aspect of that involved soil hydrology, permeability, and estimation of zone of saturation, things like that? Could you elaborate?
Yes, sir. In order to understand the ability of soils to promote growth, you have to understand the ability of available water. And available water comes to the point of where is it on the landscape position and how permeable the soils are to allow soils to infiltrate and to hold water within a growth zone. These courses were part of that. I had to sample in different ecosystems, including from bottomland hardwoods and riverine systems up to some of the higher side slopes in order to create the model that was required for my master's.
Thank you. Where's your current employment again?
I have several. I work for a large company called WSP USA, and then I work for a smaller firm called Acer Environmental out of Georgia.
Thank you. Is that out of Wilmington, North Carolina, at WS?
That's where I report to.
Well, one of your people that recommended you or vouched for you is at that office.
Yeah, that's my probably it was Nick Tudor. That's my supervisor. He's in Wilmington. I live in Asheville. Our organization at WSP is interesting.
Went on their website to get an idea of it. It looks like they do formal wastewater projects. Were you involved in any of those, and if so, how?
I have been involved in smaller wastewater projects, specifically looking at small office buildings and small businesses, nothing on a larger scale yet. I've gone out and done preliminary soil evaluations to determine suitability for specific systems, typically nothing large, maybe no bigger than 1,500 gallons per day.
Thank you. And was that under your licensure in North Carolina as a soil scientist?
Yes, sir, those were.
Okay. We call it classification here, which is somewhat of an ancient term. We don't do much classification. It seems our profession has focused on on-site disposal of wastewater, for better or for worse.
I do classifications in North Carolina and in Georgia for mitigation sites, especially in the state of Georgia, who recognizes my license and would also recognize a license from here to do classifications for, down to series for mitigation sites.
Have you done much work in the coastal plain?
Yes, I have the scars to prove it.
Me too. Okay, well, is there anything else you can add to help us understand why you have 5 hours that are not straight soil courses?
The course itself, again, is not a straight soils course, but it was a soil focus. And a lot of this comes down to, as you were mentioning, you were saying that you were called a classifier. It comes down to what's in a name. This course, although it was dealing with ecosystem classification as it applies to forestry, soil is the driving force behind that. Geology, yes, geology plays into that, but as a soil scientist, I worry about the top 6 to 10 feet and what can actually drive the ecosystems through there. That was my focus in these courses, not only when I took it, but when I was required to come in during the lab portions. And I'm digging the holes, I'm having to sit there in front of everybody, the rest of the class, explaining what I'm seeing because I'm the grad student who was under the first grad student for this professor. This was a very specific course focusing on soils, even though the name does not garner it.
Okay, thank you. Go ahead, Randy.
Okay, could you briefly describe what you did at each of those entities and
When you're saying the entities,
WSP, the two firms?
oh, with WSP, my main focus is as a wetland ecologist. Although I do soil science there, a lot of it is focused on seasonal high water table determinations and infiltration testing using a Guelph permeameter, which is a much better than the emosimeter if you've ever had to deal with one of those. I do some soil science in the effluent and some of the, getting rid of some of the wastewater through WSP, but that is not my main focus. A lot of it is dealing with infiltration, it's dealing with wetlands, it's dealing with mitigation and hydric soil delineations. With Acer Environmental, that's a company that a friend of mine owns, and I work through him when I find something interesting to do, whether it's wetland delineations, doing mitigations, or soil science itself, doing on-site wastewater systems, preliminary evaluations, as well as working with local engineers in the western part of the state doing the engineered option permitting, where I do the soil evaluations, assign the loading rates, and make the system recommendations. Lately, I have been working with a couple of local engineers doing Hurricane Helene recovery efforts because Samaritan's Purse is out there and they're doing a lot of work, and they've got about 400 sites in and around Buncombe County that need septic permits, and the county doesn't have the resources to handle it, and they don't want to.
Thank you. Just to follow up, in the state of North Carolina, it's my understanding that licensed soil scientists not only can do the detailed reports, but also completely design certain systems and have control of that from start to finish. Have you ever done any of those?
That requires a separate certification called an AOWE, which requires you to go out there and run, do the design, run it, putting in. I do not carry that certification. I want to dig holes. I want to come up. I want to do the fun part. I understand. So I understand the systems. I understand, how they're installed. But going through there, I don't carry the insurance that would allow. I don't want to carry the insurance that would allow me to take that extra step.
If it were free, would you do it?
No.
Okay.
That part isn't the soil science part.
Okay, all right, thank you. And I'm not going to wear you out here, but again, we're trying to get 5 hours out of this.
Yes, sir.
To get you to 15. You've got 2 courses, and so how can we allocate the necessary plus 5 here?
Again, those courses, regardless of the name, were a soils-driven course. They brought in other aspects. How do soils drive the forest communities?
Thank you, but for 850, how many credit hours are you asserting?
For 850 would have been, for 8050 would have been 3.
And the other one?
The other one, 8100 would have been 2.
Thank you. All righty, anything else, board members? Okay, let me get back on script here.
I've got 2 kind of questions. I mean, we do,
Please.
possibly would have the option of just kind of tabling this until this letter would come in with more information.
I've been trying to get Dr. Jones to write this letter for months.
Yeah, and you don't have a copy of the other original.
No, I sent that, this was in 1996 that I sent that one into the board, and
They probably don't keep those.
they don't, and I've moved 3 times since then, and wherever that letter is, it's well decomposed by now.
The instructors or professors that are teaching those courses now that could provide their opinion on the soil basis that was covered in those courses?
I'm not sure that those courses are taught anymore. Dr. Jones developed these courses as part of his PhD and was teaching those as the basis for the mapping units that we had to do he was trying to figure out a way to sell this to the various forest companies to help with their planning purposes. And when he left, he now does some forestry, but he's more into stream mitigation at the moment.
You've inquired with Dr. Jones, but you're still waiting for him to respond.
Yes, I've spoken to him several times over the last few months.
Thank you, Mr. Gay. Appreciate your time and your information. Your case is now submitted, and we, the council, will take it under advisement.
Thank you. I appreciate the council's time. If you have any other questions, please reach out to me as quickly as I can.
Thank you for coming.
Do Mr. Gay, you can hang out just for a little while, and we'll get back with you in just a little bit, okay?
Another question maybe for Miss Mary here. We had a grandfather clause at one point too, especially when we went from DNR, especially. Is that about right? When was that kicking in? Which maybe the timing, 70s? Okay.
It was back in the 70s. I think when the program was established in 1976, there
Gotcha.
was a one-year period that we grandfathered people in. Now, that being said, I do believe that North Carolina they did it a bit later, like into the 90s. I
Gotcha.
think we had looked into it previously, years and years ago.
1997, is that correct? Thank you.
And I think around that time, they were kind of winding that program down. But I would have to defer to legal counsel how that grandfather clause would line up with our requirements in 97. I can say I came in at 99, and the requirements have remained the same even when we moved agencies. It was still the same as it is now. You've been wonderfully consistent in that.
We had our own exam through DNR with Bob Wells at that time.
That is right. Richard Scharf, I think until he left, we used our state-sponsored exam. When Richard Scharf left in the early 2000s, we went to the Soil Science Society of America exam. I'm thinking that was maybe 2004 to 2006. It was years before our move here. We were already using it when we moved to LLR. However, we would have had that state-sponsored exam back in 97.
Thank you, Sherry. Do any of the...
Mr. Gay?
Go ahead, Randy.
Yeah, I think Mr. Gay had a question.
Sir?
We were bringing up the... when you were bringing up the grandfather clause that we had, you could be grandfathered in if you showed some experience and the education up until December 31st, 1996. Mine came in 1997 because the board, I had to explain to them that the Louisiana Tech, even though it's on a quarter system, offers semester hours. That's why mine was so late. I was the last person grandfathered in North Carolina. And my license came through in February of '97, but the grandfathering ended in December 31st, '96. But my application was in before then, and the board had questions about again, about my hours. That's when the letter got sent in by Dr. Jones, and I had to explain that Louisiana Tech's gives semester hours, even though it's on a quarter system. And that's why mine was delayed. That's all, sir.
Thank you, Mr. Gay. Fellow council members, do any of you think we need to go into executive session to receive legal counsel on this application? So please make a motion. Speak louder, sir.
Motion, we go in executive session.
Second it.
All in favor?
Aye.
Opposed? Please excuse us, y'all. We're going to have to ask you to step out while we resolve this. Please, staff, please stay present. Thank you. And then we'll,
Mr. Gay, you can come back up.
so is there a motion to come out of executive session?
I move to come out of executive session.
All in favor?
Aye.
Aye. Opposed? The motion passes. Thank you. Mr. Gay?
Yes, sir.
Our council has considered all the factors that you presented. We're going to consider your sworn testimony regarding those courses' content as valid. And in light of comity with the state of North Carolina, those two combined, we have decided to approve your application for licensure in South Carolina.
I appreciate the board's decision.
Is there a motion for a recommendation to that effect?
Motion. Second.
All in favor of the approval, say aye.
Aye.
Now it really is approved.
Thank you. And one of the things I was going to say is regardless of how this turned out, I appreciate all of your input and just the chance to meet and speak with all, especially this young lady right here who was instrumental in the process. And whatever you're paying her is not enough.
Mr. Gay, as you begin to practice soul classifying in the state of South Carolina, don't hesitate to reach out to some of us old timers regarding the way we do things around here and some of the regulations and some of the system types that you might be encountering. We can be a resource to you.
I intend to count on that.
Okay.
So we were speaking it out in the hallway. I was discussing with some of the other ones, some of the differences between North and South Carolina. And when I will be working under other people until I am sure that I am doing this right, because ethical ways of working are the only way to work.
Amen. Thank you, sir.
Thank you. I appreciate the board's time and attention.
Mr. Gay, your license will be placed in the mail, okay?
Thank you.
You're welcome.
Well, we have another hearing for Mr. Andrew Cornelius. Is the applicant present? Come forward, sir.
And Mr. Cornelius, is that your witness also?
Yes, if you
All right.
choose to.
He can come on.
Mr. Cornelius, are you by chance represented by counsel this morning?
No, sir, not today.
So you're electing to waive that right and you're representing yourself, correct?
Yes, sir.
Thank you. Have a witness or witnesses you intend to call to testify on your behalf?
Yes, sir. Mr. Travis Brown?
And what is his relationship to this matter, please?
He is the PCS who I've worked under for the past 2 years to meet the 2-year requirement.
Thank you. Would you please stand and state your names for the record? Thank you. Would you please raise your right hands to be sworn in? You promise to tell the truth, the whole truth, and nothing but the truth. You're on the record under penalty of perjury. Thank you. Mr. Cornelius, are you ready to show us how you believe your education and work experience meet our department's requirements for licensure?
Yes, sir, I am.
Okay, please make sure your red light is on as you speak. Thank you.
A quick summary for his
Oh, please
application
do,
prior to
sorry.
him
Go
going
ahead,
to,
Mr. Rose, my bad.
So just give us one moment, Mr. Cornelius. Mr. Chairman and other council members, Mr. Cornelius, he submitted an application for licensure as a professional soil classifier on December 9th, 2025. He obtained a Bachelor of Science in Conservation Management from Western Carolina University in 2017 and has 4 years, 10 months of experience. Mr. Cornelius has passed the Soil Science Society of America Fundamental Examination on August 5th, 2024, and the Professional Practice Examination on November 19th, 2025. Mr. Cornelius was issued a certification by the North Carolina Board for Licensing of Soil Scientists as a soil scientist in training on October 14th, 2024. Department staff were requesting a recommendation from this council whether Mr. Cornelius meets the education and the experience requirements for licensure.
Thank you, Mr. Rose. Please proceed, Mr. Cornelius.
Just very quickly,
I'm
Mr.
sorry.
Cornelius, no, never mind.
All right, go right ahead, sir.
Oh, you're fine. Just to start off, in my current role right now as Assistant Project Manager at Eagle Engineering in Indian Trail, North Carolina, my daily professional responsibilities center on soil and site evaluations, primarily for on-site wastewater viability, and I also support the PSC in report preparation. I believe my academic foundation paired with my professional experience and current certifications demonstrates my long-term commitment to this field. I respectfully request the council recognize the intensive soil science curriculum within my natural resource management studies as qualifying credits.
Thank you. Have any questions to ask of your witness or help us understand his support for you?
Honestly, I have him here today just to verify the 2 years. Based on the correspondence from this board, that was one of the issues.
Sir, how long have you been licensed in North Carolina and/or South Carolina?
North Carolina is just over 3 years now. South Carolina is 2 years.
Okay, and our applicant has been under your direct supervision for 2 or more years?
2.5.
And you've been licensed in South Carolina for 2?
Yes, sir.
Okay. Mr. Cornelius, is there a reason why you have applied to our board for licensure rather than the North Carolina board at this point?
So North Carolina requires 3 years under LSS, and the PSC requires 2. So I'm just trying to get my foot in the door.
And where do you reside and practice again?
We are out of Indian Trail, North Carolina, which is Union County, but we work all over the Piedmont primarily.
Thank you. At this point, is there a motion to go into executive session, or is it needed? Not?
Just for clarity on my point, the question is the 2 years of experience, is that correct? Mr. Rose, I'm sorry. Sorry. Is it, the question is the 2 years of experience, is that?
That's correct, and the
everything else?
education. Yes, sir.
And education?
Yes, sir.
Okay.
Any other council members have questions or concerns about adequate course quality in this case?
So I believe the two that would have been in question would have been NRM 460 Watershed Management and NRM 440 Integrated Resource Management, which was my capstone course. So soil science was baked into it very heavily.
Can you elaborate on that? I did look at the course description you provided. In our practice here, again, mostly on on-site wastewater, landscape position is important, but it's kind of peripheral to the actual soil descriptions and estimation of the zone of saturation and loading rate. I need a little help on what was in that course that is pertinent to these skills.
Are you questioning NRM 460 Watershed Management or the capstone?
Watershed.
Okay, I'm not sure if y'all got my full appeal package. I've provided the syllabi for both courses. You'll see that in Watershed, I would say at least 30 to 40% of the course was dedicated to soil texture, structure, porosity, and hydraulic conductivity. With that being said, soil was the primary controller of the hydrologic cycle, if you will.
Thank you. Sir, could you provide a little comment on the quality and degree of supervision of our application, of our applicant? How much time do you actually spend with him, and how much real knowledge do you have of his personal work?
For his first year, we were together every day doing perk tests, not just in North Carolina, but in South Carolina. 90% of our work is based in North Carolina. However, we do go to Lancaster and York County about 2 to 3 projects a month. For that first year, we were together every day. Towards the end of that, I would let him make his own soil calls, and then see if I would agree or disagree with it, so he would then get the knowledge of it. And then he took over, started laying out systems, watched over that, make sure it was correct, until I felt fully comfortable of him making his own call.
So at this point, can you turn him out on his own?
Yes. I have the utmost confidence in that.
Thank you. Council members, are we ready to take a vote? Or do we need more discussion? Any more questions? Very well. All in favor of Mr. Cornelius's application to be approved? Sorry. Got to get a motion to approve?
Motion to approve.
Second.
All in favor, say aye.
Aye.
Aye. Very well. The motion's passed, and you, sir, are approved for licensure in the state of South Carolina.
Thank you, sir, and I'd like to thank the board for their time today. I really appreciate y'all reviewing all my submissions.
And good luck with your North Carolina license after another year.
Yes, sir.
All righty.
Be placed in the mail for you, okay?
Thank you.
You're welcome.
Thank you all.
Both of these instances, the department agrees with the council recommendation.
Yes, ma'am.
Okay, back on track to the staff reports. Could you lead off, please, Mr. Rose?
Sure thing, sure thing. I know that we're a little late in our meeting for just a quick reminder, but if you all don't mind, just as a reminder for the record, if you can speak clearly into your microphones, and you will notify or actually notice that it will be a red light that is illuminated, letting you know that it is hot, and it is ready for you to speak into it, all of your good thoughts about everything here in the crust of our meeting. Also to let you know that we're also not just capturing here within this meeting. We do have this meeting that is also on the viewing platform of YouTube. So we want to make sure that all of our YouTube participants are very much so being able to hear what's going on here in this meeting. Just to serve as also another housekeeping reminder to all of our council members, if you were to receive any kind of correspondences from anyone, the general public, or any one of the licensees that we do have here on this council, please, if you don't mind, direct them to our office. We would love to first be that first line of duty, that first line of defense for you all. In any event, those items have to come before you for a formal presentation or just a formal recommendation or a vote for that matter. You would have to recuse yourself because you know just a little bit too much about those happenings of that case. So again, if you get any kind of correspondences, please direct them to myself or to Sherry. We'll make sure that we govern ourselves accordingly and bring those items to you should we need to for those council meetings.
Can I get an example of that? Give me like a scenario.
Sure thing.
Give me a scenario.
So if you have, let's say hypothetically, an applicant that reaches out to you and say, hey, I want to know the stance of what you may be thinking about my application, or you have a person who's already licensed, they just have any kind of follow-up questions that could lead to a potential vote or discussion of this council, that would qualify for you to send all of that information to us. And if you have, I would say err on the side of caution in any of those moments. If it's a licensee, just send it directly to us.
In other
We'll go ahead
words,
and filter.
talk to the staff.
That's it.
Okay.
That's it. I like that, Mr. Thorpe. So definitely, any moments that you have that may sound like it could be council business, just direct them straight to our office.
Okay.
All right?
So I may have a follow-up, I guess, to that, because I was looking at different, the recusal definition. It has to do with if we have prior knowledge of the case, does that have to do in our world a specific site or a goings-on of certain conditions? Or
That could be a little murky, and I'm going to refer to legal counsel on that matter because it could actually go a little bit further into detail. But then we also have not only, of course, our great legal counsel here, but we have a board member training too that may answer a lot of those questions too.
Good.
But I'm going
Okay.
to give this over to Ms. Mary Lee, and she can better answer that question than I can.
I'm going to give you, and my answer is, if you have a question about something, give me a call, because it really is dependent on how much you know and the specifics
Okay.
of what you know. Just, if you know that something out there is going on because you're a member of the profession, that, that's not an issue. But if you have had conversations with someone about something out there going on, or if you have formed an opinion about something that is going on, and you don't need to see any evidence because you know that guy's a bad guy because you've just heard terrible things about him for years, well, then you, in fairness, need to take yourself off the matter. But it is very subtle and murky, to use Johnny's word. So if you have any questions, if something has gotten you just a little uncomfortable, I'm glad to talk it through with you. The decision is always yours, unless it's an economic interest of you and your family in a specific matter. Other than that, it's just what your personal moral compass and ability to set aside some of your personal or professional relationships with someone may be.
Thank you.
There'll be a little bit more about that later.
Thank you again. Yeah, type it or talk into the.
You have some knowledge and feelings, but you feel that you can be objective.
It depends on how much knowledge you have and where you got that knowledge from. The feelings aren't as important. It's part of it is to protect the individual who's coming before the board, right? Part of it is to protect you, because you don't want someone saying that individual is biased against me, and I know that because I heard he had conversations. Y'all are a small profession. Y'all are going to know things. The fact that you know things is not a disqualifier, right? It's just when you have a more, I want to say intimate, a closer involvement with the matter. But just because you know there are issues does not take you out of the mix. Does that help?
Thank you, Ms. Mary. All right. And also, too, just want to, of course, for some more updates and housekeeping for this council. You all have been receiving some information from us, just letting you know and informing you that the 126th General Assembly convened on Tuesday, January 13th. So weekly, you will be receiving those updates from our office. We don't see anything right now that would be a hot topic for this council just yet. However, if there is something that is very much so that you need to be participatory in, we will be reaching out to our legislative contacts, either myself or our representative from our governmental affairs office, letting you know what that issue is and where your stance or where your presence should be on that time. So again, we will be letting you all know, but again, you will be also be receiving those updates from my office weekly. I want to thank you all for allowing us to speak at SCOWA on this quarter here. I know that we had some issues when it came down to the weather, so it was postponed. So I had to come in via the WebEx platform or the Teams platform because I was unable to travel myself that day. So again, thank you all so very much. From what I've heard and from what I've seen, it was definitely a great first initiative of this new association. So my hat's off to you all who had a hand in planning and also had a hand in all that development and the future developments of SCOWA. Board members, also council members, you all also have received from Sherry a reminder of the statement of economic interest forms. That filing deadline is going to be March 30th, and that time is going to be at noon. If you don't mind, please, sir, to get those reports in as soon as you can. From what we're told, there are penalties that actually do apply to that should you file those econ forms a little bit late. If you need any assistance, please reach out to Sherry or myself, and we can make sure that we help you filter through that process. The Soil Science Society of America second quarter examinations will be offered April the 8th through April the 22nd, and registration is now open until March the 30th. This council has 53 licensed soil classifiers, and no licenses have been issued since our last council meeting of last year. And Mr. Chair, just will conclude my report to give you all the finance report. That finance report, a financial report you'll find in your council materials. As of January 31st, 2026, the council has $58,472.25, and that is the cash report for this great council, and that will also conclude my report, Mr. Chair.
Thank you very much, Mr. Rose. It's nice to be solvent finally. Okay, let's hear from Mr. Waddy Horton from the Office of Investigations and Enforcement, please.
I have no reports for this meeting.
Thank you. How about from the Office of Disciplinary Counsel, Mr. Elliott?
Yes, hello, Mr. Chairman, members of the board. I think the first time I came into this meeting was about 7 years ago. I'm not sure if any of you were there then, and that was just to tell you that I'm your disciplinary counsel and how grateful I was that y'all never had any cases. That's changed. We do have one case in our office that has been marked for discipline. I think part of the board's tasks today is to find a suitable time in the month of either May or June to schedule the matter to be heard. Like I said, I hope this isn't a habit. I certainly hope this is a one-and-done situation because I've never tried one before this board. Y'all never have any discipline. But we do have one case that obviously I can't comment about the subject matter of.
Can I ask a question, please?
You can ask it. I may not be able to answer it.
Okay. On this particular case, advisory council will, I guess at some point, have input on that. And would we have time to review this prior to a meeting?
So, in terms of, I'll tell you about a case that me and Ms. League had a couple of years ago before the engineering board, which was of similar complexity, but hopefully not as long. Ms. League may faint when I say that, because we were here for a very long time. But it might have as many papers. So hypothetically, in that case, let me just say, in that case, it was scheduled for what's called a formal complaint hearing, which is something you're going to hear about in a minute. That's a full-blown trial, just to put it in colloquial terms. That's just like TV, if you allow me the parlance, in that we call witnesses, they get cross-examined, there are objections, there are motions. It's everything but a jury, except y'all are actually the jury. Y'all sit and hear this. Now, you're a very special jury in that you get to ask questions of the witnesses. Not the jury, regular juries don't get to do that, of course. So you have some special powers as a jury. But in the end, you'll hear all the testimony and evidence in those situations, and you'll hear me give my case, I'll rest, the respondent will give his case, rest. In the case that I had with Ms. League, it was a case that involved a lot of documents. Fortunately, I was able to get the respondent on the other side to agree to the documents being put into evidence prior to the hearing, I think about 4 or 5 days, maybe a week prior, to give the board members an opportunity. They didn't know, they knew what the complaint was generally about. You know, they obviously hadn't heard from any witnesses yet, but they were permitted to at least look at the doc, because it was a mound of paper. So they at least got to look at that. Now, that may or may not happen in all cases. You know, respondents who appear before these boards, they've got the right to remain silent, if you will. I mean, they don't even have to talk to me. So, although I would hope that the board could be apprised as much information as possible prior to a hearing, as with Ms. League, they weren't apprised of witness testimony, but they were apprised of exhibits in the case that she and I had together about 1.5 years ago, 2 years ago. I would hope that hearings that I have that are complex in nature would take the same format. But there is the possibility, if there's a respondent on the other side that is disagreeable about everything or doesn't want to talk to me, that you could a board could conceivably see documents for the first time at the hearing. So a lot depends. I'll do tell you, I know I've had any cases before y'all, on complex matters, you know, that have a lot of paper involved. I do make a lot of efforts to get the paper to you as quick so you have time to review, because I would prefer y'all be as apprised as possible in heavy documentation cases. So that's my long-winded answer to that question.
Thank you. Our subject matter is quite technical.
Yes, it is. And I've been learning.
Yes.
Slowly.
But thankfully, you were able to rely upon other licensed classifiers to read the tea leaves and boil it down for you. Is that?
So let me answer a general question.
Yeah.
About the investigative, which I'm probably stealing a little thunder from Waddy, which I know he's mad about, that it means he gets to talk less. But let me speak hypothetically about every board in this building. When we don't bring every complaint before the boards that we get. We don't let a member of the public file a complaint and we go, right away, we'll take it right to the board. That's not what we do. We investigate it through our investigators. Part of that investigation is taking witness statements and getting paper, gathering documents. And they take these documents and these witness statements, and they put them in a package, what's called a litigation summary, basically a digestible package for the investigative review committee to look at. Now, if you think about it, kind of like in a criminal law, a grand jury. That's kind of what an investigative review committee is. That's a neutral ground, neutral audience, where there is no respondent, just like a grand jury hearing. There's, the defendant's not at a grand jury hearing. The respondent's not there either. Now, we may have his statement, we may have his letter that says, here's my position, but he's not there. I'm there. The investigators are there. Mr. Johnny's there. And also 3 members of your profession that are not LLR employees, obviously not members of the board. They are people of your profession that we've, I guess we send them like fruit baskets or something, because they're very generous with their time to come and hear the cases. And they listen and they read the documents, and we don't bring a case. It doesn't get to me as the prosecutor unless those professional members say, what I'm reading here is a violation of the statute. It doesn't come to me. If they say, nope, this person didn't do anything, it's out. It doesn't even get to me. I am the prosecutor. Think of me as a solicitor here in South Carolina. If you watch Law and Order, the district attorney, that's my role. I bring the cases on behalf of the state, but they don't come to me unless the professional members, people of your profession that hold a license from this board, sign off. To answer your question about profession, Lord knows it's not dependent on Mr. Wharton or my knowledge of soil classification, just so you know. We don't make the call.
There is a process for licensure if you're interested.
About it here recently, I don't think I can do it. It's been I appreciate what y'all do. It's very complicated, and I have a hard enough practice in the profession that I try to currently, so I add another one. I think Mr. Wharton's going to give a report. We have a presentation for you that I probably just spoiled a third of, but that's to answer your questions.
Well, also, I believe the soil classifiers manual is available to us, and it has a kind of a flow chart and a matrix of our basic responsibilities. So I would encourage all board members to find that and review it. Some of it's just minutia, but it does show our role and our duties. I think it even mentions the recusal aspect of it.
I would also point out that you're governed by not just a statute, but a regulation which prescribes a code of ethics.
With pertaining to this profession.
Yes, this board, this council, at some point, has adopted a code of ethics in its regulations.
Mr. Wharton, he will, in his presentation coming up, he will cover like the possible outcomes that we have to deal with. You'll cover that?
Sure, that's part of the presentation, yes. And then I think I give part of it too.
Well, I've asked this of other people, and I'm probably beating a dead horse, but just for my own satisfaction, if there is an action by a licensee of any profession in the state of South Carolina, and that licensee is allegedly performing or not performing up to either the license criteria, but moreover, regardless of license, if they're doing something that is causing harm to the public and or the environment, doesn't the Department of Environmental Services stand alone have the ability to come in and say, cease and desist, you are breaking the law, rather than bringing it against the licensure of said alleged offender? Well,
I am not qualified to speak on the powers of DES, so I'm not going to do so. I couldn't tell you. I don't know. Not my. I can barely know the rules of this agency.
Okay, I withdraw the question.
Sure, thank you.
Okay. All righty, Mr. Wharton, you want to educate us?
Mary, I think we usually go into executive session during this portion. We have for other boards that I've done this with. Okay. That's fine. Okay. I was just going by what I've done previously.
Look
If there are questions,
I don't have a preference. If it's just generic training unrelated to the complaint, I don't see why.
Either or is fine with me. I was just, again, I was just going by previous experience. That is no problem at all. I think, did you email the PowerPoint out? Okay. Y'all should have a PowerPoint on your computers. We're going to start on page 10 for us. The first portion has to do with inspections, which is not a portion of this commission.
One second. Which
Yes, sir.
one? Where's this at? In there? I'm not seeing it. If it doesn't have a handle like an auger, it's a little difficult for us, so.
Fair enough.
Yes, it would be 10A.
Sherry, could you give me some help here, please, Sherry? I run a mouse. I don't know about all this touch screen stuff.
With the arrow? No, with your curve.
It'll say Office of Investigations and Enforcement, OIE Investigations. It'll kind of look like this.
Please repeat the page number where we're starting.
Page 10. It will look like this. It'll be titled Investigations. Yeah.
Oh, that's it?
I was waiting for that question too.
That'll be good for at least 4, right?
You're going on a 1.5 of this meeting.
Johnny?
He's on, his microphone's red, so he's on record.
I say anything? Not yet. Give us just one moment.
I think we're ready. Please proceed, Mr.
Okay.
Wharton.
Yes, sir. Thank you.
All right.
This is our board training for OIE, Office of Investigations and Enforcement. This is our investigations portion. The first 10 pages were inspections, as I was saying earlier, and this board does not do inspections. We have inspections for boards such as real estate, barber, cosmetology, massage, that kind of thing, but there is not one for this one. So on the next page, you'll see where we come from our initial complaints. We are a complaint-driven, completely complaint-driven. We do not go looking for people, go looking for violations. So our complaints come from the public either online, by mail, in person, or on paper. Complaints filed by are either inspections, which again, not with this board, third parties such as news articles or other agencies, if there is usually an arrest or something along those lines, and self-reports, requirements to report your own misconduct, and also any other violations that we find during the course of our investigation. It has happened before. Opening the case, a complaint is filed. It goes to our complaint analyst. Our complaint analyst looks through the complaint, talks to the complainant, looks through regulations and the statutes to see if the board has jurisdiction or if there is the potential for an allegation of infraction of license law. If both are met, the case is opened. Then it's investigated. They have 150 business days to complete the investigation. They have 5 days to reach out in person to the person making the complaint via phone call and mailed letter. There is 30 days for them to send what's called the notice of complaint to the person that the complaint is filed against. That's called the respondent. We give them 14 days to respond, 14 calendar days to respond to the notice of complaint and to give us the documentation that we've requested. I am the lead, so I review all of the case findings that are done by our investigation staff. I've kind of gone over this next flyer. I assign the investigation to the team member. They're handled in order they're received. Y'all are graced by, again, as you said, Mr. Chairman, very well-behaved licensees, so we don't get much from you guys.
Our work is also hard to detect defects in.
Yes, sir. As a real estate licensee, and my dad was a home builder, so I'm well aware of all of the things that y'all go through. The investigation length factors, complexity of issues, numbers of witnesses, and the amount of type of evidence that we have to collect. We obtain our evidence by interviewing witnesses, including the respondent. We do have state subpoena powers, and we can coordinate with law enforcement officials if need be, if that's what the nature of the complaint is. And we can do on-site visits as well.
Could you site visits?
Yes, sir. And you've got to remember, this is more of a generic for all of the boards that we have. But we can go visit the sites where the alleged violation occurred to see if we can see anything, if the respondent wants to show us anything, the complainant wants to show us anything, to gain more evidence that way.
May I ask specifically if that occurred in this complaint?
No, sir, you cannot.
All right, I withdraw it.
And this is a complaint specific. This is just a generic how we do our job here at LLR.
Understood, thank you.
And this is for every single board.
Okay.
I have 8 boards, so this is how all 8 of mine go. The investigator submits the notice of complaints that goes to the respondent for me to approve, as well as what's called the litigation summary, which is a write-up of all of their findings. I review it, I make sure everything's in order, everything is needed, the best of my ability. If not, I'll send it back to them to get more information. I'll sign off on it if it's complete. Then it'll go to our investigative review committee. Once they look at it, they'll make a determination of their recommendation, whether it should be a formal complaint or a letter of caution, which is, for lack of a better phrase, a note going in your permanent record like it did back in school, or a complete dismissal. A letter of caution to the public is also considered a dismissal. As Mr. Elliott described earlier, our investigative review committee is Mr. Rose, the professional members, the investigator, myself, and Mr. Elliott as well. The IRC, when we do have cases, I try to get those cases to them. They get the entire file. They get the entire litigation summary. Try to get them to them about 2 weeks prior to give them plenty of time to look through, make sure they have any questions to formulate for when we have our meeting. We had to try to do them 2 weeks before the board meetings, just so we make sure we have enough time to get our paperwork to you guys so y'all can review it. Our IRC reports, we have two different reports, or two different columns. One is the allegation. That is, we put that in immediately upon receiving the complaint, before we even talk to the respondent, talk to the complainant. It's our overview of what the complainant said. The IRC logic explains the reasoning behind the IRC's recommendation. So if they ask for a dismissal, we explain why in that column. If it's a formal complaint, we'll just say formal complaint again. So we don't, where you guys don't have to recuse yourself and we accidentally give away too much information.
And that's the stage we're in now, even though we're curious and want info, it's still behind the curtain.
Yes, sir.
Okay,
It's behind the paywall, so
Thank
to
you.
speak.
okay.
Want the information. Don't have to recuse ourselves. We don't want
Right.
the information right now.
Exactly. That will be up to Mr. Elliott to give you all the information during when the disciplinary council, or during the disciplinary hearing, and he'll be going over that in just a second. I think you guys can either approve the IRC recommendation, edit it if you think that the IRC made a mistake of issuing a letter of caution when it should be a formal complaint, or as an example, you have the ability to change that. Y'all could vote on it and we would change it to what you think. That's basically all for me. It's pretty cut and dry. Do y'all have any questions?
Thank you, sir, appreciate it.
Sir, thank you.
Okay.
Okay, turn it over to me in the Office of Disciplinary Counsel. So I'm on that title page in your packet there. Turning that page to the ODC leadership page. There, I'm on the far right there. I'm one of 5 supervisors. We supervise 5 other attorneys in our office. There's currently 11 of us. There on the far left, Tina Brown is our boss. She's the chief disciplinary counsel. Turning that page to general ODC duties, as I explained earlier, think of us like a prosecutor's office, a solicitor's office. We take in cases that have been approved by the IRC. We we prepare them for trial. In my normal courses, I get them ready to try, and then I start talking to the respondent so that, I have some leverage. So, we gather, sometimes we have to gather a little bit more information, start coordinating witnesses, meeting with witnesses on occasion for complex cases, obviously drafting, preparing legal documents, and then, of course, the hearings themselves.
Sir, when you say respondent, would that be analogous to the accused or the defendant?
Defendant, yeah. If you think about in criminal law, we say defendant. Here at LLR, we call them respondents. Okay, that's the person against whom the discipline is aimed.
Understood. But you said something about twisting their arm or getting them to interact with you. Is that?
It's not, let me say again, I've done hundreds of cases for other boards. We have other boards where sometimes respondents just don't talk to you. They don't talk to his guys, they don't talk to me. Yeah. So, I mean, and when I go before boards, I make that known, particularly if they're not there the day of the hearing. If they don't show up for a hearing, I make it known. They never talk to this guy, they never talk to me, they're not in this chair today. That is other boards. If you're, I doubt that will happen in your board. Next page, case resolution after formal complaint approval. So formal complaint approval is when the IRC says prosecute this matter. That's what formal complaint approval means. That means it comes down to our office. Generally, for most of my cases, I start preparing it for a trial. I want to have my witnesses, I want to have my exhibits, and sometimes I'll just schedule the hearing, and then we'll talk, because I don't like to negotiate without leverage. So there are agreements we can enter into that we'll get into a second, but a lot of the times, for a lot of my boards, I want to schedule a hearing so that I'm able not to negotiate with air. You know, I'm ready to try it.
When you say enter into agreements, is that pre-trial or prior to a hearing?
Pre-trial,
So-
and we're getting ready to go into those.
Sorry.
Sure. If you look at the next page, there's a flow chart there. So some boards have what's called consent agreement parameters. Y'all have probably never discussed that because you never had any discipline. You know, you never needed consent agreement parameters. We have boards that get over 1,000 complaints every year. So to help with the prosecution of that volume of cases, the boards will tell us, for instance, let's say the contractor boards, hey, if they don't pull a permit, just do a thing for $500. We'll take $500 for that. Or you take an engineering board, they practice without a license, that comes to this amount. You know, I've got a pre-programmed fine to offer.
Also known as copping a plea?
That would be pleading guilty
Okay.
to not only and then you're also pleading to a sanction too. I not only say I'm guilty, I agree to take this reprimand. I agree to take this, and that ends the matter without a hearing. Okay. Like I said, this board's never had a case, so you've never had a reason to do consent agreement parameters. I'm not asking you to do that now. The other agreement there is what's called a memorandum of agreement. That's basically a guilty plea where the respondent, we enter into an agreement, we put all the paper together. It's a big package of everything you would need to make a decision. The respondent comes in, we say, look, this guy admits he messed up. He just wants to plead for mercy, kind of give his side of the story, and then y'all figure out what to do with him. But in that case, if he's done that, I don't have to prove anything. He's pled guilty, if you will. This is like going before the judge, pleading guilty, and then the judge issues you a sentence.
Or no locandere?
Say again?
No locandere?
No, if we were doing that, we wouldn't be before the board.
Okay.
That would be, if we decided not to prosecute a case, you wouldn't be seeing that. A memorandum of agreement is, again, an admission of guilt. That I will say many, many times at a hearing to put that, make sure the board's aware. They're admitting guilt. They're admitting guilt. I don't have to prove guilt. You're just here to tell us what the punishment should be. Another agreement we can enter into, and this is where I get less fond of these things, is a stipulation of fact. That's where we agree the event happens, but we disagree that it's a violation of the Practice Act. You know, I put up the video of the man jaywalking. I say he's jaywalking. He says he isn't, and y'all have to decide whether or not he is or not. We all agree the act happened, but he says it's not a violation. I say it is. Y'all make the determination if it is or not, and if it is, what the sanctions should be. I don't particularly care for those. Formal complaint, that's a hearing. That's what we've discussed earlier. That's a full-blown hearing where we call witnesses, cross-examination, the usual. Voluntary relinquishment, those are rare. That's basically where the respondent just says, I see where this is going. I'm just going to give up the practice and give up my license for good, So those are some of the types of agreements. The next page, consent agreement. I'm not going to spend a whole lot of time on there because we discussed it, and frankly, y'all don't have consent agreement parameters anyway. So the consent agreement, again, is an admission of guilt and an agreement as to what the punishment should be. The next page, memorandum of agreement, we just talked about that. Again, that's an admission of guilt where y'all will just determine the sanctions. The next one there, stipulation of facts. I think we talked about that one again. It's just an agreement as to the facts, but not the violation. Next page, formal complaint hearings. I think we've talked about that enough. That is a trial. As far as the next one, panel disposition. So at the end of these hearings, y'all have options. One, of course, is just dismiss it. Y'all can find that there's insufficient evidence of a violation, case dismissed, not guilty, if you will. There's violation and sanctions. That is, you find a finding of guilt, if you will, a finding of a violation. We believe this person violated the Practice Act, and here are the repercussions for that. Then there's sort of this middle ground, this letter of caution, where it's like, something probably bad happened here. Look, we just feel like you need to do better in your practice, but we're not going to tag you with a public reprimand. Most what we call reprimands or finding of violations are public. They're published on our website. That's part of the sanction, is that you've got to wear that. Anybody that looks up your license in perpetuity will see if you've been reprimanded by this board. Anybody that holds a license that is supervised by LLR, you can go on our website, you can type in their name, find their license, and as a part of their license page, it has to be a current license, I believe, you will see if they've ever been disciplined by their governing board. Not just soil classifiers, all 43 boards. You can look that up.
Is that a permanent blemish on their license?
There is no expungement process, Ms. League, I believe, for any boards, correct?
There is an expungement process for several boards, but
Thank
you
you.
actually have to adopt one. And this council has not.
Yeah, I don't have a board. They do? I need to talk to them about that.
And it's generally just a first-time offense for something that's not a gross violation of the Practice Act. It's sort of a, hey, you messed up one time, you keep your nose clean for the next several years, and
I'll have to look into that one. I didn't know engineers had one. I'll have to look into it. But this board does not have such an animal, correct, Ms. League?
correct.
Okay. Next page, panel dispositions. I think we've already kind of got into this. What potential sanctions are. Public reprimand, continuing education, fines, probation, supervision. I don't, and Ms. League, I haven't delved deep enough into which ones of these may apply with this board, but these are general. Suspension, and of course, every board can revoke a license.
Elaborate on the probation option.
I might can. So in the boards that I've had, let me speak to my own experience. For instance, I've had maybe the contractor board issue a public reprimand and a fine and a 1-year probation, meaning if they got another complaint later within that 1 year, it would most likely lead to revocation. Keep in mind, there are no sentencing guidelines like in the criminal law, which is tough for me to explain options. And for this board, even tougher because I have no prior, if I go over here to the residential board where I've tried dozens and dozens of cases, I can kind of tell you about what they're going to do. But keep in mind that the statute doesn't say if you do this, the most you can get is this. If you do this, the most you can get. It doesn't say that. It says these are the things you can do wrong, and the board can do this up to revocation. So that you're really bound by this board, because nobody's nobody in my office can remember a soil case. I don't have any precedent in terms of how the board handles discipline. Like I do other cases, when I talk to a respondent and I go, look, I can show you multiple cases where the board has found this to be a violation. Don't you want to enter into an agreement? That sort of thing.
One more question,
Sure.
please. Have you ever had, in other disciplines or licensures, have you ever had a case where the chairman of the licensing board of the council was asked to go straight to suspension of a license without a hearing?
Yes. Sure. So, and that's coming up. There's something, can I hold that question until we get to it?
I'm sorry, I'm jumping ahead. Go ahead.
Absolutely.
So could you define supervision as far as like, in our case, like who, because I'm assuming to be LLR supervising a certain person, like what staff would that be?
Well,
How would that take place?
That's an interesting question for this board. So you think about maybe, I think sometimes they do this in nursing, Mary. I've never had a case where supervision has been ordered. I think maybe on the health side, like you need to be supervised by an older nurse, that sort of thing. Mary, I'm struggling, I'm sorry.
No, so supervision could be having, I think maybe engineers, have someone look over your work, right?
But-
Just someone kind of going behind you
We just
for a
want-
certain period of time to make sure that that individual has figured out what they did wrong and has corrected that practice.
Is that a board assigned person?
You would assign another licensee to do that. You would have to find someone to do it. It's a lot harder to require that in professions that don't have a natural order of supervision in the workplace.
Would that said supervisor report back to the board on their progress?
That is something y'all could require, a board could require. Yes, generally you do.
And I apologize for not being as familiar. I think this is something that happens on the health side more than it does the business side.
What is a suspension with stay, please?
So and this is addressed later, but I'll address it here. Keep in mind, when any board in this agency hears a case and they say, we revoke this licensee, or they say, we're going to fine this licensee a public reprimand $1,000. That's not necessarily the end of it. Your decisions aren't necessarily final. They can be appealed to the administrative law court. Now, that's down there on the State House grounds, black robe judge, and they sit in an appellate posture reviewing the board's decision. Well, do they have enough evidence to say to revoke that guy? Did they sufficiently give a good enough reason why they felt they needed to revoke him or issue him a public reprimand? And what they usually are doing, we don't appeal. If I get a case dismissed, state you didn't prove it, dismissed, I don't appeal. We don't appeal. We just say that's the end of it. But we do get respondents who are found in violation of the statute. The board rules on it, says you're in violation of statute, we suspend you, we fine you, whatever. They do take their appeal to the administrative law court. There's a very nice lady who has been taking notes like she is here, creating a record, all the exhibits that went in, they just review it like an appellate court. And then they pass judgment on it, and if the respondent doesn't like that, he can appeal to the Court of Appeals. And if he doesn't like that decision, he can plead to the South Carolina Supreme Court, and then it would be the rarest of occasions if it involves some United States constitutional issue, the United States Supreme Court, yes.
Would they be more picking on like, process type of things or actual, probably not details of soil science and that kind of thing,
They
correct?
tend to give you all they tend to give boards a lot of deference on your specific technical knowledge. So it's really more pressure on me. I'm viewing it from my perspective of me putting in the evidence for y'all to make a decision. Like I didn't just get up here and go, man, this guy messed up so bad y'all wouldn't believe it. Case closed. And y'all say, yep, revoke him. Obviously that wouldn't be enough evidence. The pressure's on me to help. When I'm trying a case before boards, I'm not just thinking about y'all. I'm thinking about downtown and what they're going to think of the record. So that's why I usually, create a pretty fulsome record so that there's plenty, if y'all decide to discipline, I'll hang my, because I'm probably one of the ones that's got to deal with the appeal anyway. I can hang my hat that y'all had enough information. With regard to stay or without stay, when the appeal, let's say you revoke a guy. Oh, go ahead, Mary.
You mind if I take this one?
Please.
Because I have actually dealt with this on
Pretty please.
on some boards. And so I'm going to backtrack to the very, very briefly when we were talking about building a record. The responsibility is on Mr. Elliott to give you the evidence. But y'all's task is to, in your decision, explain how you get where you go. So you can't just say revoked. You got to say, I looked at this evidence, and this evidence, and this evidence, and this evidence, and this is my conclusion. So just make sure you understand, it is not a simple, we make a motion to revoke. You have to show your work, right? So how you get there. But a suspension with stay, I have used in boards where there are like specific reporting requirements. One board that deals with money, they have to submit annually to the board an accounting of that money to ensure it has been appropriately used. In some cases, if someone is having difficulty finding an appropriate professional to prepare that financial report for them, the board could say, look, you've had time to do this, and we're really running out of patience. But if you say you can get this report in by X date, we will do that. So what we will do is, because you haven't complied, and we think this is a very important provision to comply with, we will suspend your license, but stay the suspension for a specific amount of time, so that you have the opportunity to comply. And it could also be that you needed to get continuing education, but you hadn't gotten your continuing education. So you suspend the license for, say, 6 weeks pending compliance, and if you don't do it within that period, then your license is suspended. So it's sort of a shortcut so that you don't have to bring that person back in for another hearing if they fail to comply. So that's how it has been used in some other boards, Chris. I didn't mean to jump in there, but.
One slight little follow-up to that, though, also, but if it gets appealed, that's where certain things like possible recusal comes into question, whether they might challenge if someone should have been recused and that affected the decision, those types of policy type of thing, that's where that would be challenged, is that correct?
That's the pathway for a recusal challenge, but you would still have that argued generally up front, and it would so have to be after discovered, I guess. I've never really had.
I mean, I've never had a recusal. I never had a case where recusal was an issue. I've never had a case where a respondent said, that person needs to recuse themselves, and they're not doing it. And the person, like, I've never even had that happen. So I can't comment on the process. I would say that the issue, I mean, for preservation issues, it would have to be argued at the time of the hearing. Ms. League, you can certainly correct me, but I do believe it would have to be made an issue at the hearing.
Well, I feel like I'm back in law school.
I know you. That's okay.
These are good questions.
Okay.
No, these are great questions. I mean, it could be after discovered. You didn't recuse, and then someone found out afterwards that you had spoken and said, yeah, I knew that. I knew from, 5 months ahead of time I was going to vote that guy's license needed to be revoked, and in that instance. So it is an appealable issue,
Yes.
but it's harder to raise, I think.
So I've got questions about the recusal such situation. I don't know if you're going to cover it more in detail a little bit.
I am not going to cover recusal anymore, and if they're
Okay.
specific, Ms. League might want to do them in a different venue. So,
Okay. Okay,
And that's part of what I'll be covering, so we can.
very good. Thank you.
One last question about dispositions. The disposition of the board, would that set a precedent for the future, for if
Well,
similar
I mean,
cases came up?
for me, it would. For instance, if, for other boards where I do lots of cases, let's say I have lots of cases, and I've tried a case one time, and the boards looked me dead in the face and said, this isn't a violation. Like, why are we looking at this? And then I'll go back and tell Mr. Wharton, And when we have IRC says, guys, we ain't trying this again. The board already said this isn't a violation. Conversely, if the board looks at a case and says, this feels like this is a fine, then I'll say, hey, respondent, I've tried one like this. Look at the order on this one. It's just like your case. Why don't we agree to a fine and do a consent agreement? So that's how I would use it. As far as board, I don't even remember the last soil case. So if y'all have one every 10 years, I don't know that we have to worry about precedent.
We're going to be setting precedents every step of the way.
Yeah, well, potentially. I every case is fact specific. So, I'll let Ms. Lee handle that concern.
I'm just going to very briefly dovetail into that. As far as how the board or council will handle the next case, even if it were similar, what is done in one case is not necessarily binding on the next case. There have been numerous cases at the appellate court level where respondents have argued, yeah, but you did this to this guy, and the courts have said every case is different. So there is some benefit to having a board's perspective on a particular case, but as the ultimate result, it's really not going to be something that is set in stone from henceforth and herewith.
Right, and every case is, even the simple ones are fact specific, frankly. Looking at the next page, respondents' due process. So before they get to me, I think as Waddy covered, they are contacted by our investigative staff. They're apprised of the complaint. They're apprised of, what the basics of the complaint is. They're, that as soon as they get it, they can go get an attorney. They can go get an attorney at any point in the process, or they can basically represent themselves throughout the entire process. They can come to a hearing and represent themselves. They have that, you have the right to represent yourself in LLR hearings. Certainly, that's part of the IRC process. If a respondent is communicative, maybe not cooperative, but communicative with our investigators and want to do a written response, that's something that the investigators will include so that the IRC members can consider their side of the story on a written basis, even though they're not at the hearing. Certainly, going through this, they are apprised of the case in investigation. They can absolutely get an attorney at any point or not get one. Anything that I present to the board in terms of evidence, they will have seen beforehand. They will have likely seen it from Mr. Wharton, a lot of it. And of course, if we were to do a contested hearing, we are governed by the rules of evidence, so they can object to the presentation of certain evidence based on permissible objections, and which Ms. Lee would guide you through in that situation. And as we mentioned, they have the right to appeal, so they run out of recourse. The next page, other legal disciplinary related issues, and this goes back to your question there at the top, a temporary suspension order. So for a lot of other boards, we have basically from the board direction, if a licensee does this, we want you to submit a TSO for consideration. A TSO is a temporary suspension. It's basically a motion, and it's made by somebody in my office. It's basically, even though it's not styled as a motion, that's basically what it is. It's where I put together an affidavit, like any other motion. It's like temporary injunction in the civil courts, if you're, hopefully you're not familiar, but if you're familiar. So in boards cases, they're made to the board chair by and through the advice council, where we say, Mr. Board Chairman, we've gathered these terrible, terrible set of facts, and they're so bad that we're motioning that this person be suspended, even though they're not a party to this motion. It's what's called ex parte without them. And we have to feel like it's really bad. Now, some boards have automatic conditions for TSOs, like let's say, I'll pick on the nursing board again. The nursing board again, let's say you have a nurse who's under an order to attend counseling for an alcohol problem, and they stop going. That would be an automatic TSO from our office. This person was supposed to be going to their alcohol counseling. They stopped going. The counselor told us, got an affidavit from the counselor, and they're now a danger to the public. This is a TSO situation, okay? Now, for this board, just like you don't have consent agreement parameters, you don't have any hard and fast rules about TSOs. So hypothetically, if I were to make that motion, I would have consulted first with professional members of our IRC and said, okay, professional members, is this that bad? And without their say-so, I wouldn't even issue the motion. That is an extraordinary remedy. If a TSO is issued from any board, the person on the receiving end of the TSO has a right to challenge it. Basically says, I want a hearing. This TSO was falsely issued. This is baloney. I shouldn't be suspended. And they will get a hearing just solely on whether or not they should be suspended on a temporary basis. It's not even the whole merits of the case. It doesn't decide the whole case. It just decides whether or not there should be a suspension at all. They will appear with counsel, most likely. I basically have to prove the reasons why the suspension is necessary, prove that it's an emergency, danger to the public, all that stuff. And again, it's an extreme remedy. And because it's an extreme remedy, trust me, there's a lot of due deliberation over it. But that is the suspension order process. If a suspension order is issued, then it remains in place until the case is over. So let's say I get a case where a contractor's convicted of, let's just say he's convicted of robbing a bank or something, and we TSO the guy. But we also have an underlying case that'll eventually will come up for prosecution, and then the result of that case, the TSO will go away. They may decide to revoke the guy, or they may decide, basically suspend him forever, or they may decide, this was just a fine after all. So they do end, thus temporary. A cease and desist, that's when you have an unlicensed person practicing a profession. They don't have a license. They're out there doing something they're not licensed to do. The board can issue a cease and desist order. That is an order from the board. If you run afoul of those too many times, I take you over there to the ALC and ask them to hold you in contempt and conceivably put you in jail. An extreme remedy that I've never had to do for this board. And then, of course, the agreements to surrender or relinquish the license, which I believe are explained on the next page. Not the next page, excuse me, in the coming pages. The next page is TSO. I think we've discussed those pretty fully. The next page is on cease and desists. Again, this hasn't come up for this board ever. Agreement to voluntary surrender. This rarely comes up from my business boards. It usually comes up in the health side. It's where at the beginning of the action, doctors tend to do this. They surrender their license kind of temporarily. It's a non-disciplinary surrender, and then it holds until the actual case is heard. So I don't deal much in these, to be honest. The ones I do deal with a lot is the next page, the agreement to voluntarily relinquish, because that ends the case. But that is a permanent surrender. If you permanently surrender your license, you're done from the profession. And those are rare, very rarely. I would say occasionally I see some builders who practice in other states. Sometimes they'll do that. That is my part of this presentation that I see. I'll be happy to entertain any questions or turn it over to Ms. Leake.
Okay, so I'm just going to start off with a general overview, and then where that leads. Y'all are, as you know, one of the licensing entities under the LLR umbrella. The purpose of a licensing board or council or commission is to protect the public while recognizing the ability, constitutionally protected, of an individual to practice a lawful profession, to earn an honest living. So what y'all are doing is balancing public protection and the rights of y'all's licensees. That means that you need to come to a balancing process when you're looking at whether someone is qualified to practice your profession. So you do this through your licensing decisions, and then you also do it through the disciplinary process. Now, you've seen the application hearings. That's very similar to what you would see in a disciplinary case without the lawyer directing the testimony, right? You're taking evidence, you're hearing testimony, you're asking questions, you're making a decision. You're not going to see disciplinary counsel involved in an application hearing because it's strictly y'all's decision and doesn't have anything to do with their ability to practice other than whether or not they have met your licensing qualifications. The disciplinary part of y'all's job, which I think is what we're really focusing on today, is where you're looking at whether someone who has been issued a license is still minimally competent to practice the profession, or if they have slipped in some way and need to be brought back into proficiency. So I'm going to reframe a tiny bit what the consequences of a decision by this board, this council is, in finding that someone has practiced in a substandard manner and unethically. I do not view sanctions as punishment, because as the licensing board, you are here to determine if someone is qualified to practice. And the sanction is that tool that y'all have to either get someone back to a proficiency level, either by reminding them through a fine, which is $500 per violation, or restricting their scope of practice, or suspending them for a period of time or until a condition is completed. Or if they can't be brought back to competency, revoking their license. So the whole point of your determination is not, are we going to, how hard are we going to hit this person, right? It is, what do we need to do, or can we bring this person back into a qualified status? Briefly, I'm going to kind of talk to you about some of the things that guide your decision-making along the way. You have your Practice Act and your regulations. They sort of establish the baseline for what someone needs to practice competently. Then there are constitutional provisions. Mr. Elliott talked about that, due process rights of an individual. Part of that is this sort of complicated process that we have here at LLR with Mr. Wharton as the investigator, Mr. Elliott as the prosecutor, and y'all as the adjudicators. The South Carolina Constitution requires that in an administrative setting, a quasi-judicial setting, that the provisions of due process apply, and the same person cannot be the investigator and the prosecutor and the adjudicator. And that's why these functions have been separated out and kind of insulate y'all in a disciplinary case until that last minute when it's decided there is no other resolution to this case than to bring other provisions of the Freedom of Information Act. That's why we're doing things in open session. It requires that the agenda be posted in a timely manner. And it also requires that y'all conduct your business in a transparent and open session. That's why you have the agenda, so people are aware of what is coming up. That's why you are asked to not talk about matters ahead of time, so that any decision you make is a result of the information you receive here, information that has been received from another source that may or may not be reliable, conducted so that the public has confidence in your decision-making, whether it's finding someone qualified or finding someone who's not qualified. You can go into closed sessions on a couple of occasions and still be in accord with the Freedom of Information Act requirements. One is closed session, and y'all don't see that very often. You'd see it mostly in healthcare professions, and that's when you are protecting someone's information that is healthcare related, medical, substance abuse, or mental health treatment. The other provision that you can do is you can go into executive session. And that's very limited, because that's when you take everyone out. There's no record of what's said, unlike in a closed session when you just ask people to leave that aren't involved in the matter, and you still have a transcript. In an executive session, everyone is asked to leave unless you need consultation from staff, and if nothing is retained as a record. And that's because you are receiving legal advice. I am y'all's attorney, and attorney-client confidentiality applies to what I may tell you about how to look at interpreting a law. Y'all are the final arbiters of what that interpretation is, but I can help guide you with that, and that is why that is done in executive session. You're also bound by the Ethics Act, and I think Johnny has spoken to you about filing your financial disclosures. But what is sort of pertinent to y'all's decision-making in licensing and disciplinary matters is the requirement from the Ethics Act that you're not allowed to participate in matters where you or a family member have a financial interest or business relationship with an applicant or a respondent appearing in front of you. And in that case, that's when you would have a recusal, and it's not discretionary. If you have someone who's going to benefit financially from any kind of relationship with an individual in front of y'all, you have to step away. You also cannot lobby. That's another Ethics Act provision. No boards at this agency no board members have the ability to act as a lobbyist. This agency cannot act as a lobbyist. You can serve to educate a lawmaker on a particular issue if you're asked to appear and testify before them in your professional capacity as a board member. That, however, mean you cannot speak on something as a member of the profession or as a concerned citizen. You just have to be careful to delineate the difference when you're speaking, whether you're speaking as Mary League licensed soil classifier, Mary League member of the association, or Mary League council member. Because you don't want anyone to get the wrong impression that you're attempting to speak as a council member when that's not the intent. And I mean, you can't really speak as for the council, right? You don't know what everyone else is thinking on that, and it's not fair to the fellow council members, and it's not fair to the person relying on your information. So let's talk about recusal, and I'm just going to very kind of briefly hit it. And if you have questions, then I think we could probably go into executive session for legal advice, because I think it may be fairly specific. But in addition to having the financial interest, which is a mandatory recusal, there are other due process considerations requiring recusal that are not mandatory. And that's sort of at your discretion when you feel like there may be an issue with hearing a case that makes you uncomfortable. So if you have prior knowledge of the facts of a case, or if you have bias or prejudice, either for or against someone appearing before you, then you need to recuse. For example, you go to church, you have someone you have worked on the Sunday school committee for years and years, you know that person, you think they are stellar, and they're also a licensee and they have a case that comes before the board. You may, I mean, there's just no way I could ever think that that person did something wrong. And even though I don't have a specific prejudice against them, I have a strong prejudice for them. So maybe it's better if I step away. It could be when you have more information about a case than just general buzz in the community. I mean, taint, that's the word we use. It means you have been tainted. You have heard something you shouldn't have heard, and you heard about it, and you decided to go do some research because you wanted to know a little bit more. Now, all of a sudden, you found yourself with a whole lot of knowledge about something that's outside the parameters of what would come to you if the matter were to be on the agenda. So in that instance, if you have significant prior knowledge or personal interest in the outcome of a decision, then the best practice would be to recuse yourself. Now, we can, there'll be a motion to go into executive session?
Like to.
Can we go into executive session?
Executive order.
Executive session for legal advice?
Session for legal advice,
Right.
please.
Thank you.
All in favor?
Aye.
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 Aye, the motion passes. Now we're live and on the record. Thank you. All right, well, that was pretty instructional, and I'm sorry it took so long, but we have a lot to learn here. Let's move on to the review from Mr. Rose about CE broker and audits and all that.
All right, thank you so much again, Mr. Chair, but I know there are two separate items, B and C. I can wrap it up in just one item. It's just going to be more of a discussion, and I would also ask that we could possibly vote on this because we do want to utilize this as another mechanism for our upcoming renewal. So just to serve as a reminder to this great council that CE Broker is the tracking system that is used to track and verify the continuing education for all licensed professionals here at LLR. It acts as that centralized platform where education providers, they could report those course completions, or our registrants and licensees can actually do that same thing themselves. You can also use that platform more so to house those CE documentation there. And it also helps monitor compliance, conduct audits, and confirm that licensees have completed the required CE process before renewing their licenses. So essentially, Council Member CE Broker simplifies that process by keeping all the CE records in one place for providers, for those professionals, and also for us as regulators. So in simple terms, it's just that platform that keeps that record for us just to reach back, just to get those documentations for compliance. So we brought this to you all, and I know that you all have utilized CE Broker some time ago. We are wanting to incorporate this into the upcoming renewal in 2027 to where we will build this into our renewal process, and all of our individuals or all of our licensees, they will be able to go in and report their continuing education hours there within that renewal documentation, and it will actually interface with that CE Broker software. But again, just wanted to bring that to you all for that discussion. We are getting ready to go ahead and prepare now for that 2027 renewal. So it will take a little bit of time and configuration for us to get with CE Broker just to make sure that everything works well when we do open up that renewal in 2020, end of this year, 2026, for the 2027 renewal period.
So the voluntary participation period is ending with this vote.
Yes, sir. Yes, sir. The agency has come into a contract with, an agreement with CE Broker. So this is an agency initiative. It's not just a board specific. A lot of boards are not utilizing this software because a lot of boards don't do continuing education. However, those boards that do have continuing education requirements, we're asked now to look at those audits and look at those CE requirements just a little bit more in fine detail. Not only do we license individuals here, of course, you know that, but another piece of the agency's stance, of course, is the compliance piece, and CE requirements will be that piece of the compliance.
Is there, how many people volunteered to use CE Broker, or how many did not, I guess?
So we have 52 boards now, Mary. Is it 42?
Going to be 54.
3 plus 2, it'll be 55 coming.
Yeah.
Oh, boards, sorry.
Yeah, we have a lot of boards.
I plead guilty. I need to get on board. But if we have to make it formal, then let's do so.
Yeah, and we'll make it very much so simplistic when it comes down to the enrollment piece of it and just signing up for that CE Broker module. So we'll make it very, very simple for that. Yes, sir, we'll do that, and what we'll do, and this is going to be one of my initiatives with all of my program areas, is we're going to do mostly a soft launch, and that soft launch is basically making that announcement to all of our licensees, all of our registrants, letting them know that we're moving towards this. This is a great initiative so that those individuals who do take those CE courses, I've had a number of individuals reach out and say, well, I don't know where my CE documentations, where they are right now. Well, we have a cure for that, and that CE Broker, once you complete those, you can go ahead and upload it into that system, and then it houses that information for you.
Out, I think, and we have CEs, but is it Are people using it currently?
Yes, sir. So I have 4 other program areas, and out of my 5 programs, I have at least 3 of my programs on CE Broker.
So it's, for us, it would be available right now or in the near future?
Yes, sir. In the near future, not right now. We're going to still work on that configuration just to make sure that it's going to be very simple. I would love for it to be that one-click option. Would love for it just to be a one screen when it does come down for that renewal time, that you just key that number of continuing education hours in. But again, we're going to get with CE Broker to see what their process is, again, to make it very simple for all of our licensees that will be utilizing CE Broker.
Oh, and also ARCPACs and Triple SA, this is what they've been doing for quite a while.
May I have a motion to approve the CE Broker program for our profession?
I move to approve the CE Broker program.
I second it.
All in favor?
Aye.
Aye. The motion passes. Let's go digital.
Thank you all so very much.
Anything-
Most of us still do our reports by hand, paper and pencil and all that, so it's kind of a, including me. I've done CE Broker too, so it's, you know.
Are we at our final item now, or is there something else?
Yes, sir. We're at our final item,
Okay.
10D.
The special meeting, since the ex parte immediate suspension did not happen, I feel like we owe the respondent a very timely resolution to this, because there's a lot involved, including various people's livelihoods. So I guess the burden's on Mr. Elliott and his team to give us a timeline, a reasonable timeline that we can convene a special meeting. Our next meeting technically is in September, but I don't want to string it out. So we need to coordinate with you to get us back together in this room and do the thing.
Mr. Chairman, with regard to that, I posited, based on how cases normally go, May or June to be sometime in that time frame. I gave Ms. League I consulted with my own schedule and the schedule of the witnesses that I would be bringing, and I gave her a list of, please don't schedule for these days. So there are ample days to choose from in May, and June. And Ms. Lee, how do you want to do?
Look at my schedule as well.
Yes, good.
If you don't mind, these are some dates that I think work for Mr. Elliott and for me. That would be May 8th, May 18th, 19th, 20th, 22nd, 26th, and 27th. Then in June, 9, 10, 11, 16th and 17th, the 19th, the 22nd, the 24th, 25th, and 26th, and then 29th and 30th.
Not the 29th, Ms. Lee. Yes, ma'am.
Apologies.
Personal thing, and I'd like to be here, but all of June.
Okay.
So if,
Sooner the better if we can coincide. I don't have my calendar before me. Do we have to pick a date in this moment, or can we look at our various schedules and coincide on one? How would that work for you guys?
If I may, Mr. Chairman,
Yes,
if I may, a couple things from my end. Number one, a respondent is entitled to 30 days' notice of the hearing. So if you're going to pick a May day, you need to pick it quick. The other issue is that the more time we give the respondent, if he gets an attorney involved, I would like the attorney to get involved as soon as possible. So if we're going to do May, which it sounds like we are, just let me know quick, if you can.
I hear you.
Yeah.
I think we need to fish and cut bait here. Does anyone have an open calendar on their phone or something? Let's get some days of the week here. So what day of the week is the 8th and the 18th, please, Randy?
May the 8th. May the 8th is a Friday, and May the 18th is a Monday.
19th, obviously, is a Tuesday.
Yes, sir.
Yep, I can do that. I kind of like Tuesdays coming to Columbia. How about the 19th? Y'all?
That's clear for me.
Can you make it clear? I mean, we're all pretty flexible, I would think.
Yeah, oh, yes. I anticipate when y'all give me this date, I'll have this out of my office early next week.
Okay.
So that'll
Check
be about
that.
45 days, and that's plenty of time. That'll be notice under the statute, yes.
Check. And how long do these things usually do we have to show up at 8 and be ready to leave at 5? Is there any way to?
And I can't tell you, I think starting in at 10 is a fine. Ms. League, I don't know how far these gentlemen have to come to Columbia.
It's normal for us.
Yeah, I think your normal 10 o'clock time, but pack a lunch. I do think it's going to last into the afternoon.
Literally, we're here until we make a
Make a decision.
decision or pass it for some other reason.
Yeah, I've never had a board hold things in abeyance, even though I've asked in the past. I think advice would kill us, but I think you're pretty much bound to this room until you make a decision.
At one time.
You did it one time, Mary. Where were you?
We were still trying a case at 9 o'clock at night.
Wow.
I don't anticipate that happening in this. Yeah. Just pack a lunch.
That's what we're hoping for. Let's.
Okay.
Okay, do we have to have a motion, or is this just, administrative?
If you would vote on a special call meeting for May 19th with the date to be adjusted if necessary.
So moved. Can I get a second?
Second that motion.
All in favor?
Aye.
Aye. Motion passes. The 19th of May it is. And thank you for your time.
Sure.
All righty, are there any public comments at this point? All righty then, may I have a motion to adjourn?
Motion.
Please.
Second.
All in favor? Aye. This meeting is adjourned.